Test, test.
Test 1, 1, 2, test 1, 2.
Mr. Johnson has arrived, so we can do it. Welcome, everybody. Sorry for the heat in the room. I understand we've called about getting the air conditioning going. We say on Capitol Hill, it's not the heat, it's the stupidity. So we'll try to keep both of them down to livable levels during our hearing today. The Committee on the Judiciary, Subcommittee on the Constitution, Civil Rights, and Liberties will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. I want to welcome everybody, all of our distinguished witnesses, and everybody in the crowd to today's hearing on congressional authority to protect voting rights after Shelby County versus Holder. I am, going to recognize myself first for an opening statement, and then turn it over to Mr. Johnson. We'll swear in the witnesses, and then we'll get going. So today's hearing is part of a series that the House Judiciary Subcommittee on the Constitution and Civil Rights is holding to assess ways that we can reinvigorate the preclearance requirement of Section 5 of the Voting Rights Act, which was so badly damaged by the Supreme Court in Shelby County versus Holder. While voting rights are a central part of our national narrative and self-understanding, continuing efforts to deny the vote and block suffrage rights for excluded groups have been as much a part of our history as the proud exercise of the franchise by those who enjoy it. Congress passed the landmark Voting Rights Act in 1965, but it was won by the blood, sweat, tears, and martyrdom of countless brave Americans in the civil rights movement, like Mickey Schwerner, James Chaney, Andrew Goodman, Viola Luisa, and Medgar Evers, people who gave their lives struggling for the universal right to vote and strong democracy everywhere in our country. The act mobilized federal power to protect the fundamental right to vote against political white supremacy, focusing on jurisdictions that used a literacy test or a character exam and where a majority of African Americans or other minorities were disenfranchised. The key innovation was the Section 5 preclearance requirement. The basic problem with laws against disenfranchisement is that even if you're able to prove the disenfranchisement and punish the offenders, the election is long since over. And so the damage to democracy and to disenfranchised communities has already been done. So the architects of the Voting Rights Act required covered jurisdictions, those with the most sordid records of racial disenfranchisement and oppression, to obtain approval of any changes of their voting laws or procedures from the Department of Justice or the United States District Court for the District of Columbia in advance. The preclearance requirement ensured that the proven racist jurisdictions would bear the burden of proving that any changes to their voting laws were not discriminatory before they were allowed to take effect. It thus provided a mechanism to ensure that any new voting rules and practices in jurisdictions with a history of discrimination would actually be fair changes. In this way, preclearance proved to be a significant means of protecting the rights of minority voters, and it empowered millions of African Americans, Latinos, Native Americans, and other Americans to register and actually vote. This is why Congress had repeatedly reauthorized the preclearance provision on an overwhelmingly bipartisan basis, most recently in 2006 when the House passed reauthorization by a vote of 390 to 33 and the Senate by a vote of 98 to 0. But in 2013, the Roberts Supreme Court effectively gutted Section 5 and destroyed the preclearance mechanism when it struck down the coverage formula that determined which jurisdictions would be subject to the preclearance requirement. It held that the decades-old preclearance requirement was now an unjustified intrusion into state sovereignty because the coverage formula failed to reflect current conditions. It essentially held that the coverage formula now violated equal protection, not equal protection of the people, but of the states, a fairly remarkable turn of events. In any case, the preclearance provision is dormant and useless unless and until we adopt a new coverage formula to replace the one that was invalidated by the court. Although the court struck down the coverage formula in Shelby County, it noted that it issued no holding on the preclearance provision itself. The court indicated that Congress could draft another formula based on current conditions. As we've seen in the 5 hearings we've held so far on the problem, the Shelby decision opened a new era for formerly covered jurisdictions implementing a broad array of discriminatory new voting tactics and devices. North Carolina, for example, passed a strict voter ID law that a federal appeals court ultimately struck down as unconstitutional, finding that it intentionally targeted African Americans for disenfranchisement with almost surgical precision. Yet as the litigation wound its way upwards, elections took place for office holders at the federal, state, and local level. In other words, judicial nullification of the preclearance provision paved the way for precisely the kind of voter disenfranchisement that Congress had intended to prevent when it adopted the Voting Rights Act. We've learned of other profoundly troubling recent state efforts to turn the clock backwards, including by widespread polling place closures and relocations, the practice of purging voters from the rolls in a way that targets racial and ethnic minorities, and the imposition of aggressive restrictions on ex-felon voting. With the current new generation of voter suppression tactics in the wake of Shelby County versus Holder, America is being served some of the same nasty old wine in some new bottles, and in some cases, even the bottles themselves are recycled. Congress must act, and we have the power to do so. The considered opinion of many constitutional scholars, including many here today, several here today, is that our authority to stop race discrimination in voting remains expansive, even within the terms of the Shelby County ruling. The 14th and 15th Amendments, of course, gave Congress explicit legislative power to enforce voting rights and equal protection against deliberate race discrimination. These amendments form the basis of our authority to pass the Voting Rights Act in the first place, including the preclearance requirement. When the Voting Rights Act was first challenged the year after passage, the Supreme Court in South Carolina versus Katzenbach upheld the preclearance provision and its coverage formula, holding that congressional authority to enforce the 15th Amendment is broad and comprehensive, and that implementing legislation must pass only a test of minimum rationality. Does it reasonably advance a legitimate state interest? I also note that the Elections Clause, which confers authority on Congress to regulate federal elections, could further bolster and does further bolster the Act's constitutionality. The court in Shelby County hardly addressed these foundational sources of congressional authority, but even on its own terms, the Shelby County decision left precedent standing that recognizes our authority to act to protect the voting rights of the people. So this is why we've invited the panel together today to come and advise us on this process. I thank our witnesses and our members for being here today, and I look forward to a lively and substantive discussion. It is now my great pleasure to recognize the distinguished ranking member of the subcommittee, the gentleman from Louisiana, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. Thank you all for being here. It's an important issue. This is our 5th hearing, as was mentioned, and as I said at our last one, we all agree. I mean, I think every member of Congress would agree openly that discriminatory treatment in voting based on race or sex is abhorrent. It's, of course, prohibited by the Constitution, as it should be, and it's prohibited by federal statute, as it should be. But too often, complaints of discrimination in voting have nothing to do with discriminatory treatment. Instead, rules entirely neutral on their face are sometimes claimed to be discriminatory simply because they have a disparate impact on one group or another. But we make the point so often that disparate impacts are not proof of discrimination. Indeed, they're statistically inevitable. Yet the bill we'll be discussing today, H.R. 4, would prevent states from enforcing their neutral voting rights laws if they aren't approved by the Justice Department, and that's an entity with a history of politicizing that power in the past. And it would do so based on claims of disparate impact, which are statistically inevitable and not evidence of any racially discriminatory treatment per se. Take the example of the Department of Justice's letter declining to preclear South Carolina's voter ID law under the Voting Rights Act as it existed in 2011. The department claimed in the letter that, quote, minority registered voters were nearly 20% more likely to be effectively disenfranchised, unquote, by the law because they lacked a driver's license. But the difference between white and African American holders of a driver's license was only 1.6%. The Justice Department used the 20% figure because while the state's data showed that 8.4% of white registered voters lacked any form of DMV-issued ID, as compared to 10% of non-white registered voters, the number 10 is 20% larger than the number 8.4. So it's true mathematically that 10 is 20% larger than 8.4. Actually, it's 19% larger, but the Justice Department rounded up. But it clearly distorts the reported difference in driver's license rates, and it was used to falsely declare the South Carolina law discriminatory. What other factors might then explain differences in outcome among demographic groups? Well, to give just one example, data shows that younger people among both African Americans and whites tend to be the least likely to have driver's licenses. Consequently, if African Americans have proportionately more young people in their demographic group, there will be a disproportionate number of African Americans without driver's licenses, however slight, as is indeed the case. That's not discrimination. That's just math. It's demographics. The disparate impact approach to civil rights and the assumption that different outcomes are the result of discrimination is fundamentally unsound for the same reason social scientists are trained that correlation does not imply causation. In other words, there can be all sorts of correlations between one event and another, and that doesn't answer the question as to why the correlation exists. Regarding discriminatory treatment in voting, that's based on race. Section 3 of the Voting Rights Act, which is permanent federal statutory law, remains in place and in full effect. It allows any federal judge, upon proof of discriminatory treatment in voting based on race, to subject the offending jurisdiction to whatever preclearance regime the court deems appropriate. But H.R. 4 would go far beyond what is constitutionally permissible, and it would allow a politicized Justice Department to veto or amend state voting laws to the political advantage of the party in power. As one of the witnesses before us today will explain, Congress cannot constitutionally enact legislation denying states and localities control over their voting rules when there's no evidence they've been engaging in discriminatory treatment in voting based on race. The Supreme Court's holding in City of Bernie v. Flores held that a law enacted pursuant to the 14th Amendment must be congruent and proportional to actual constitutional violations that can be established in an evidentiary record. In considering whether a law satisfies Bernie's congruence and proportionality standard, the court assesses whether a record of actual constitutional violations exist, that is, intentional discrimination in voting based on race. The Supreme Court has taken a dim view of statutes aimed primarily at eliminating disparate impacts that don't themselves violate the 14th Amendment. But that's just what H.R. 4 does. This committee and other organizations have claimed to have compiled evidence to demonstrate the need to amend the Voting Rights Act, but the list of examples overwhelmingly includes DOJ objections to state and local voting rules changes under Section 5 of the old Voting Rights Act, Section 2 cases, and cases in which a jurisdiction may have stopped defending the case after the district court level. Department of Justice Section 5 objections are just that, and not official determinations by a court of ultimate jurisdiction that a state or locality actually engaged in disparate treatment and voting based on race. Section 2 cases can continue to be brought today, just as other civil rights cases are brought, so such cases don't demonstrate the need to amend the Voting Rights Act. And cases in which a jurisdiction may have stopped defending the case or settled the case after the district court level may simply indicate the jurisdiction couldn't afford to continue appealing the case up to a higher court, where the jurisdiction may ultimately have won if it could have afforded to. Lots said there, lots more to discuss, and with that, I look forward to hearing from all of our witnesses today. We do appreciate your time, and I'll yield back.
All right, thank you very much, Mr. Johnson, for your opening. We welcome all our witnesses, and I want to thank you for participating in today's hearing. Please note that your written statement will be submitted to the record in its entirety, and we ask that you summarize your thoughts in 5 cogent minutes, if you would. There's a timing light on the table. When the light goes from green to yellow, that indicates you've got a minute to go. When the light turns red, it signals that your 5 minutes have expired. So all you law professors, take note, and I'm speaking as a law professor here. Before proceeding, I hereby remind each witness that all of your written and oral statements made to the subcommittee in connection with this hearing are subject to penalties of perjury, pursuant to 18 U.S.C. 1001, which may result in the imposition of a fine or imprisonment of up to 5 years or both. Our first witness is Justin Levitt, an Associate Dean for Research, a professor of law at the Loyola School of Law in L.A. He was previously the Deputy Assistant AG in the Civil Rights Division of Justice. He's published many excellent pieces in the Yale Law and Policy Review, the Harvard Law Review, and so on, and I've learned a lot from his work over the years. And Professor Levitt, you are recognized now for 5 minutes.
Thank you very much, Mr. Chair, Mr. Ranking Member, distinguished members of the subcommittee. Thank you very much for the opportunity to testify. Federal legislation is essential to protecting voting rights. The courts have done serious damage to the current enforcement regime. Bipartisan action should restore it. The members of this committee who were able to vote in 2006 on the last reauthorization, Republican and Democrat, voted for the last reauthorization, and I very much hope to help the committee reach a similar consensus here today. Congress has the broad power to guard against racial discrimination in the franchise. I am, in fact, one of those scholars you mentioned, Mr. Chair. The 15th Amendment, as just one example, is devoted entirely to the topic. The Constitution has only been amended 27 times in our history, and one explicitly prohibits discrimination in voting. That speaks both to the importance of the issue and the urgency of addressing it. The 15th Amendment also expressly gives Congress the power and responsibility to enforce that prohibition through appropriate legislation. This is an enumerated power. It is not less than the enumerated power to regulate interstate commerce. It is not less than the power to regulate the armed forces. It is not less than the power to appropriate spending for the common defense and the general welfare. This is a responsibility that Congress was given, and one that I'm increasingly encouraged that you are taking up, including with this hearing here today. The Supreme Court has also been quite clear that this enumerated power is not confined to the four corners of the amendment itself. It includes the power to block state practices that, and I quote, perpetuate the effects of past discrimination. And it includes the power to, and I quote again, prevent and deter discrimination on the horizon. And the structure of H.R. 4 is squarely within that power. Even while confining federal authority in other areas, the court has repeatedly held up the Voting Rights Act as the exemplar of congressional authority. This is the thing that is most well-founded on Congress's constitutional bulwark. And there's only one meaningful exception to that. It's the Shelby County versus Holder case in 2013. I'm not a fan of the Shelby County decision, but its legal rule is simple enough. Congressional action has to be reasonably related to current conditions. The court thought that the formula for pre-clearing new laws, reauthorized in 2006, took its core from 1964 turnout statistics, and the court found that 40-year disconnect irrational. Shelby County gave us more than that legal rule. It gave us a problem. Preclearance was an extraordinary remedy for an extraordinary concern, racial discrimination in voting. It is still sadly necessary. Indeed, after several Texas cases highlighted in my written testimony, preclearance is more necessary than ever. Shelby County neutered it. Most civil rights legislation, most civil rights litigation is responsive. If there's a legal problem, you sue, you prove harm, remedies make the plaintiff whole. But enforcing voting rights is different. Discriminatory election laws skew the terrain by which officials hold office. When they fight tooth and nail to keep the skew, to keep their jobs, they don't bear the costs, the taxpayers do. If taxpayers disapprove, they can't toss the offenders out because the election rules themselves are the problem. In no other arena is the incentive for officials to discriminate so personal and the costs so dispersed. Enforcing voting rights is different. Voting lawsuits are also complicated, the sixth most complicated in federal court. They are expensive and they are slow, with years to develop evidence and years, as you mentioned, Mr. Chair, to resolve. Voting rights are different. Meanwhile, also as you mentioned, Mr. Chair, elections infected with discrimination don't wait. We know that elections have consequences. Discriminatory elections have consequences too. Discriminatory elections produce incumbents who end up making policy, and even if you eventually get the election structure right, that doesn't fix the policy of the meantime. There's no way to make voters whole after a discriminatory election. Enforcing voting rights is different. After Shelby County, the existing tools to defend against this discrimination are insufficient. But Congress can and should fix the damage Shelby County created well within the rules Shelby County handed down. The court explicitly invited Congress to pass a new basis for preclearance reasonably related to current conditions. H.R. 4 does that. It looks for current patterns of recidivism and stops them in their tracks. The other remaining provisions of H.R. 4 are similarly all based on constitutional authority. I've pointed to my written testimony. I look forward to discussing in Q&A. I thank the members for their time.
And thank you very much, Mr. Levitt. Franita Tolson is the Vice Dean for Faculty and Academic Affairs and Professor of Law at the University of Southern California Gould School of Law, where she teaches in constitutional law and election law. She's written a wide range of topics in the field of election law, including partisan gerrymandering, campaign finance reform, the Voting Rights Act of '65, and the Reconstruction Amendments. Her luminous research has appeared in leading law reviews, including the BU Law Review, the Vanderbilt Law Review, the Alabama Law Review, and many others, and we are delighted that you came all the way out, Professor Tolson, and you are recognized for 5 minutes.
Thank you, Mr. Chair, ranking members, and distinguished members of this committee. Thank you for the opportunity to appear and speak about the scope of congressional power to protect voting rights. This issue has been at the core of my research since I entered the Legal Academy over a decade ago. My brief comments will focus on how Congress has broad constitutional authority to enact H.R. 4, authority that includes the Elections Clause of Article 1, Section 4 of the Constitution. In addition to its power to enforce the guarantees of the 14th and 15th Amendments, which prohibit racial discrimination in voting and elections, the Elections Clause of Article 1, Section 4 provides that the states shall choose, quote, the times, places, and manner of holding elections for representatives and senators, but subject to Congress's authority to, quote, make or alter such regulations. As I have argued in my scholarship, this provision forms the basis of our system of federal elections by giving states plenary authority to set the ground rules while Congress retains a veto power over state regulations. Congress's authority under the Elections Clause is, in the words of the Supreme Court, paramount. The Elections Clause has been overlooked as a source of authority for the Voting Rights Act of 1965, even though the clause provides additional authorization for its provisions. In Shelby County versus Holder, the Supreme Court held that the coverage formula of Section 4B of the Voting Rights Act was unconstitutional. In striking down Section 4B, Shelby County accorded no significance to the fact that authority for the VRA rested on both the 14th and the 15th Amendments. There was also no consideration of the Elections Clause. In the post-Shelby world, this has created substantial confusion about the level of deference that the court should accord to Congress when reviewing the legislative record of any federal voting rights legislation. Congress can reduce the risk that the Supreme Court will invalidate the coverage formula of the Voting Rights Amendment Act by explicitly relying on provisions, like the Elections Clause, that bolster federal power when coupled with Congress's enforcement authority under the 14th and 15th Amendments. The Elections Clause has its own set of unique values that place a premium on congressional sovereignty, and Congress has, on occasion, imposed substantive requirements that states must follow in structuring federal elections. The overarching purpose of the clause is to ensure the continued existence and legitimacy of federal elections, so the text empowers Congress to displace state law and commandeer state officials towards achieving this end. The Elections Clause avoids many of the traps that have constrained congressional power under the Reconstruction Amendments. By depriving states of the final policymaking authority that is the hallmark of sovereignty, the clause is impervious to the federalism concerns that have constrained congressional action under the 14th and 15th Amendments. The clause is also distinct from these provisions because the clause does not require any evidence of discriminatory intent in order for Congress to intervene, providing further justification for a legislative record that shows that states acted with discriminatory effect or in ways that otherwise abridge or deny the right to vote. The Elections Clause can also indirectly affect regulations long considered to be in the domain of the states, voter qualification standards, and procedural regulations that govern state elections. It is difficult to insulate these regulations from the reach of federal power. Not only do voters in state and federal elections have the same qualifications, but state and local governments use many of the same practices in federal elections as they do for state and local elections. Voters register to vote, go to the same polling place at the same time, and vote on the same ballot for federal, state, and local elections in most places. As a result, a voting change affecting state and local elections will also affect federal elections. If a voting change will have the effect of undermining the health of federal elections, then the Elections Clause provides sufficient authority for Congress to regulate those changes. H.R. 4, if enacted pursuant to the Elections Clause and the Reconstruction Amendments, would address all of the objections lodged against the preclearance regime by the court in Shelby County versus Holder. The court was concerned that preclearance for covered jurisdictions was determined based on outdated information rather than based on current voting rights violations. H.R. 4 links preclearance to voting rights violations committed in the state in recent decades, the existence of which illustrates that the state has failed in its obligation to protect the right to vote, such that federal intervention is required under the 14th and 15th Amendments. H.R. 4 also addresses constitutional objections that seek to challenge congressional power to premise liability on violations of federal voting rights laws that, unlike constitutional claims, do not require the plaintiff to establish discriminatory intent. The Elections Clause, when coupled with the 14th and 15th Amendments, provides sufficient constitutional justification for a regime that premises liability on both discriminatory intent and effect. Because there is no requirement of discriminatory intent under the Elections Clause, this decreases the amount of intentionally discriminatory behavior that Congress has to amass in compiling the legislative record for H.R. 4. With the authority granted by these provisions, Congress's constitutional authority to enact H.R. 4 is substantial. Thank you for the opportunity to discuss my research. I welcome any questions that you have.
Perfect. Thank you, Professor Tolson. And Debo Adegbile is a partner at WilmerHale, a member of the U.S. Commission on Civil Rights. He is testifying here today in his personal capacity At WilmerHale, he co-chairs the anti-discrimination practice. He has served up on the Hill as senior counsel for the Senate Judiciary Committee, advising then Committee Chair Senator Leahy on a number of issues, including voting rights. He's worked also for more than a decade for the NAACP Legal Defense and Educational Fund and was its chief litigator. He argued Shelby County versus Holder before the Supreme Court in February of 2013. We're delighted to have you, and you're recognized for 5 minutes.
Thank you, Mr. Chair, Ranking Member, and members of the committee. It's good to be with you here today. As you've heard, I'm here today as a voting rights litigator, a citizen, and somebody who's concerned about the future of voting rights in America, and in my personal capacity and not in any other. Today, I would like to talk to you about and focus my testimony on 2 broad points. The first is the impact the court's decision in Shelby County has had on our democracy, what we lost as a result of that decision. The preclearance protections of the Voting Rights Act of 1965 brought profound benefits to American democracy. In many ways, it was the VRA that helped the nation realize the promise of our democracy for the first time in our history. Of course, much work remains to be done to improve and guard our democracy. No single law or policy has been more effective than preclearance in guarding equal voting rights and blocking and deterring the scourge of racial discrimination in elections. We know this because this Congress has passed a number of other statutes previously that did not get the job done. In a sense, the preclearance process served as a sort of democracy checkpoint, keeping the road to the ballot box ahead safe by preventing discrimination from risking serious harm. Most cars stopped at checkpoints are, of course, not violating any law, and there is an incidental burden imposed on those on the road. But checkpoints stop some cars that are very dangerous. We're glad they do, and knowledge of checkpoints may deter reckless driving. But our democracy checkpoint is gone, and Shelby County is unfortunately regarded by some as a green light to impose discriminatory voting measures. The adverse effects are felt inside, and I would argue outside, of the covered jurisdictions. Inside the formerly covered jurisdictions, measures that would have otherwise been blocked, in some cases that had been blocked, went into effect in the absence of pre-implementation protection. More broadly outside the covered jurisdictions, Shelby County has had a signaling effect that the federal government was in retreat regarding minority voting protections. We have lost a law that prevented scores of discriminatory laws from going into effect. We've lost a law that gave us transparency and accountability that comes from having a system where election changes are scrutinized before they take effect. We lost the deterrent effects of preclearance, and we lost the signal that preclearance sent that our national government remains what Charles Sumner called the custodian of freedom and stands willing and able to stop local governments from subordinating minority groups in the political process. There's another important aspect of voting discrimination to keep foremost in mind. Voting discrimination usually occurs through laws and practices that affect large numbers of voters, as we've heard today. A single discriminatory polling place change or redistricting map can adversely affect thousands or tens of thousands of voters. And once the benefits of incumbency vest, in many cases it's difficult for litigation to undo or rectify the harm. Second, I want to address some potential constitutional questions. When Congress reauthorized the VRA in 2006, it legislated against a backdrop of an unbroken line of Supreme Court authority, holding in case after case that the VRA's preclearance protections were constitutional. Indeed, when the Civil War ended, the Reconstruction amendments provided Congress with substantial affirmative power to finally enforce the founding principle of equality. Those amendments provided new and specific authority for this body to act to ensure that voting rights are protected, stating that Congress shall have the power to enforce this article by appropriate legislation. The election clause, as we've heard, is another source of congressional authority. Those powers remain undiminished by the Shelby County decision, and this body holds the power, constitutionally vested in it expressly, to continue the fight to protect voters through prophylactic measures. The Supreme Court decision in Shelby changes none of that. And I argue that the coverage contemplated in the VRAA is responsive to the current conditions guidance that the court gave us in Shelby. The Supreme Court invited a new measure, a new coverage formula, and that's what this body intends to do with the VRAA. Importantly, Section 3 lays out a new coverage standard that replaces the old one. The basic rule is that if there's contemporary and persistent voting rights violations, that a state or county meets a threshold, then you will be subject to preclearance. But if you improve, you can change your status and get out of preclearance. I close with a larger thought about how we should look at all of this. As Congress approaches this legislation, it does so with the knowledge that we're decades away from 1965 and in the tumultuous wake of Shelby. As is the case with the Shelby County opinion, we are too often told that things in America have changed. Thankfully, that's true in many significant ways. But the success of the Voting Rights Act is best understood not as an endpoint, but as a beginning on the road to minority inclusion. Thank you.
Thank you, Mr. Adegbile. Professor Michael Morley teaches at Florida State University College of Law. He also works in the areas of election law, constitutional law, remedies in federal courts. Received his JD from Yale Law School in 2003. And we are delighted to have you with us. Professor Morley, you're recognized for 5 minutes.
Mr. Chairman, Ranking Member Johnson, and members of the committee, thank you very much for inviting me here today to testify. It is an honor to have the opportunity to offer thoughts about Congress's authority to protect voting rights in the Voting Rights Act is one of the most important strata in the firmament of election law. For decades, it has been called a super statute, part of the institutional backdrop against which other laws are enacted. Ensuring its continued vitality is a continued priority. Over recent years, and particularly following the appointments of Justices Gorsuch and Kavanaugh, a majority on the U.S. Supreme Court has placed greater emphasis on enforcing a textualist, originalist, and structuralist approach to constitutional interpretation. Among other things, this has led the conservative majority on the court to enforce greater restraints on the scope of the federal government's authority, enforcing federalism-based protections for state sovereignty, and limiting the judiciary's ability to enforce its own conception of fairness in the electoral process. The court's ruling in City of Bernie v. Flores, curtailing the scope of Congress's authority under Section 5 of the 14th Amendment, was a first warning sign that the majority on the court would require that laws enacted under that provision be tailored to the protection and enforcement of constitutional rights, and that Congress's power to enact prophylactic measures is limited. The court sounded an even louder and more urgent warning in Northwest Austin Municipal Utility District No. 1 versus Holder, in which the court voiced concerns about the VRA's formula for identifying covered jurisdictions. Finally, in Shelby County, the court invalidated Section 4B of the Voting Rights Act, holding that the list of covered jurisdictions, which was up to a half-century old, was too outdated to support the imposition of the strong medicine of preclearance. As many other witnesses have pointed out, the Shelby County opinion invited a dialogue with Congress on these critical issues, and the Voting Rights Advancement Act of 2019, H.R. 4, reflects an important step toward accepting the court's invitation. I urge this committee to reflect on the court's recent precedents, particularly the limitations that the current conservative majority on the court is likely to enforce. This committee has held hearings across the nation, heard from scores of witnesses, compiled a voluminous record of tens of thousands of pages, and devoted countless hours to crafting a response to Shelby County. Millions of people's rights hang in the balance. Enacting a law that the current conservative majority is likely to invalidate would be a Pyrrhic victory and a setback in the cause for voting rights. Bernie and its progeny identify a range of factors that the court takes into account in deciding whether or not a law falls within the scope of Congress's power under Section 5, or put another way, whether a law is congruent and proportional to preventing violations of constitutional rights. Among the factors that the court has placed the greatest weight on is whether the law prohibits a wide range of state action that doesn't itself actually violate the Constitution, whether the law targets and prohibits state action that has a disparate impact on members of certain groups, the breadth of the law, whether the law itself prohibits state action that doesn't intentionally violate constitutional rights, and finally, whether the law is of national applicability. The more of these factors that apply in a particular case and to a particular statute, the greater the likelihood that it would be invalidated by the current court under Bernie. I would point out 4 main aspects of H.R. 4 that I would urge the committee to consider. First, the H.R. 4's definition of voting rights violations may be too overbroad to satisfy Bernie's congruence and proportionality test, and I'm happy to talk about that in the Q&A. Second, I believe the committee should reconsider the bill's treatment of political subdivisions. As currently drafted, an entire state, including every county and municipality within that state, could become subject to preclearance based on the acts of a handful of other jurisdictions over the quarter of a century, acts in which most of that state's towns and counties, of course, had no involvement and had no power to stop. Third, the concept of practice-based preclearance, while a creative attempt to address Shelby County, is at risk of being invalidated under Bernie. And finally, Section 6E of the bill, prohibiting changes to state election laws from occurring unless certain disclosures are made, raises questions that the provision should be amended to address. Thank you very much for your time.
Thank you very much for your testimony. Joe Rich retired in 2018 from the Lawyers Committee for Civil Rights Under Law, where he served as co-director of its Fair Housing and Community Development Project from 1968 until 2005. He was an attorney in the Civil Rights Division of DOJ, acting in various roles, ultimately rising to the position of chief of the voting section between 1999 and 2005. Mr. Rich, welcome, and you're recognized for 5 minutes.
Chairman, and opportunity.
Is that on?
As you noted, I worked at the Department of Justice for 37 years. 1999 to 2005, I was chief of the voting section. I'm testifying today in my individual capacity, not on behalf of the Lawyers Committee or the Department of Justice. And it's based on my long career enforcing civil rights laws that has informed my perspective of the Voting Rights Act and the continuing need for restoring the full protections of the Act which were lost as a result of the Shelby case. The Voting Rights Act of 1965 is the most important and successful civil rights law ever passed, but the Shelby County decision gutted the preclearance provisions which are the heart of the Act, provisions which have been crucial in stopping discriminatory voting changes and laws before they ever took effect in states with a long history of discrimination. The most devastating impact of this decision, in my judgment, has been the loss of the deterrent effect of Section 5 that it had on the adoption of discriminatory voting laws in those jurisdictions that were covered by Section 5. This has been particularly true in the context of redistricting legislation in which racially gerrymandered and discriminatory districting has been created by legislators and their consultants without public participation. For example, the day after the decision, the Shelby decision, Texas reinstated a redistricting plan previously objected to by the department under Section 5. Another example is set forth in a recent study by the Leadership Conference on Human and Civil Rights, which found that some 1,688 polling sites had been closed in the wake of Shelby County decision, many without notice or input from the communities impacted by these changes. The majority of these changes took place in jurisdictions formerly covered by Section 5, including Texas, Georgia, and Arizona, and many were in majority-minority areas, resulting in a discriminatory impact on voters of color. Had preclearance provisions been in place, it would very likely have prevented a significant number of these discriminatory closures. The gutting of Section 5 has also resulted in a loss of transparency. When Section 5 was in effect, the Department of Justice provided on its website valuable information about voting change submissions and the status of Section 5 reviews for the public. Now voters and advocates in the formerly covered states and local jurisdictions are often in the dark about discriminatory voting changes. The loss of the preclearance provisions has also severely curtailed the ability of the Department of Justice to deploy federal observers to monitor elections. This was an important provision of the Voting Rights Act that permitted observations of elections by specially trained personnel from OPM inside polling places and where the votes were being counted. Before Shelby County, jurisdictions that were covered by Section 5 could be certified by the Attorney General for federal observers in situations where there was evidence of possible racial discrimination. Without Section 5, this authority has been lost. The proposed legislation will reinstate the Attorney General's authority. Importantly, it will also provide new authority to send federal observers to Section 203 jurisdictions to ensure that language assistance required by 203 is provided to limited English proficient citizens in a fair manner. In conclusion, it is now time to enact legislation to restore the important protections that minority voters have lost as a result of the Shelby decision. Reinstatement of a preclearance requirement for jurisdictions found to have had numerous recent voting rights violations will deter and stop discriminatory voting changes before they go into effect. Reinstating the Attorney General's authority to certify federal observers will help ensure elections free from racial discrimination and provide language minority voters an equal opportunity to vote. Thank you.
Perfect, with 2 seconds to go. You've done this before, clearly. Ms. Kira Romero-Kraft is Managing Attorney for the Southeast Office for the Latino Justice Puerto Rican Legal Defense and Education Fund. In that role, she provides direct representation for clients in civil rights cases, including those with voting rights claims. Beyond her litigation work, she organizes outside coalitions regarding immigrant rights, voting rights, and criminal justice reform policy, and works to educate the public and policymakers about these issues. Ms. Romero-Kraft, welcome. You are recognized for 5 minutes.
Chairman Raskin, Ranking Member Johnson, members of the committee. I am here in my capacity to represent Latino Justice PearlDeaf. We have led the way in ushering bilingual voting systems to the benefit of millions of language minority voters. Today, we use litigation and advocacy to protect those rights, to stop discriminatory purges of eligible voters, and to stem the dilution of Latino voting strength. I thank you for the opportunity to testify before you about the ongoing discrimination and challenges faced by language minority voters in Florida when they attempt to exercise their fundamental right to vote, and why reinstatement and expansion of the federal observer certification by the Attorney General to Section 203 covered jurisdictions, as proposed in H.R. 4, is of critical importance to ensure that language minority voters enjoy the full protection of the Voting Rights Act. I began working with the Nonpartisan Election Protection Coalition when I joined Latino Justice as Managing Attorney in 2017. As a result, I have fielded many complaints about discrimination suffered by voters of color and language minority voters during elections in Florida, and have witnessed firsthand the resistance of election officials to fully comply with the language assistance requirements of the Voting Rights Act. There's a saying in Spanish, es mejor pedir perdón que pedir permiso. That translated to English means it's better to ask for forgiveness than to seek permission. That is essentially what the abolishment of the preclearance requirement has done to the voting rights of citizens no longer protected by Section 5 of the VRA. I am here today to testify specifically about how after the Shelby County decision, the U.S. Department of Justice took the position that the Attorney General could no longer certify jurisdictions for the assignment of federal observers, thereby preventing DOJ from using this important tool to combat discrimination against language minority voters inside of polling places. An example of a recent case where federal observers at the polls may have made a difference in Florida involved the failure of the state and numerous Florida counties to provide language assistance to Puerto Rican voters after Hurricane Maria, where our state had welcomed an influx of refugees with limited English proficiency in 2018 as required by Section 4E of the VRA. And to be clear, Section 4E applies across the country. Our calls to election officials to address their obligations to provide Spanish language assistance under Section 4E went substantively unanswered. Our organization, Latino Justice and Demos, filed a lawsuit against the Florida Secretary of State and 32 Florida counties that would have forced Spanish-speaking voters to vote in English, a language that many of them do not understand. Because of our election protection activities, we also learned that polling places in counties named in the lawsuit were failing to provide materials and assistance as per the court orders. Had federal observers been stationed in these polling locations, they may have ensured compliance and deterred the continuing violations of law. Federal observers would have had the authority to investigate and report out on these violations. The court granted our motion to stay the case pending a rulemaking process for statewide Spanish language ballots as initiated by the governor as a result of our litigation. Yet despite the court order and the governor's mandate, we are still met with resistance in order for the supervisor of elections to obey the law. Comments made during the May 21st, 2009 rulemaking workshop held at the supervisor of elections conference included these. It is not in the Spanish culture for Latinos to do this type of work. Now, my grandmother was 100% Cuban. It's my culture. We don't volunteer for these things. I tried to hire people that didn't even have to go to poor worker training. They just had to sit and translate. I paid them. They wouldn't do it. This was met to clapping. And yet your proposed rule is likely to inflict a lot of financial damage and a lot of inconvenience and a lot of wasted time. These and many other comments were made by Supervisor of Elections, and we, as a nonprofit organization, are unable to be inside of the polling station. So we are unable to monitor how these discriminatory acts are taking place. The H.R. 4 provisions reinstating the ability of the Attorney General to certify jurisdictions for federal observers and the ability to certify Section 203 jurisdictions for the assignment of observers would undoubtedly help deter and prevent discrimination against language minority voters and ensure that they receive the mandatory language assistance as observers may be stationed inside of the polls to monitor the assistance the voters are entitled to receive under the law. We lose the trust of voters by not passing this law to reinstitute the preclearance requirements for the states, showing a history of violation of voting law. Seeking forgiveness once the harm is done rarely results in an adequate remedy once it comes to voting rights violations, as a professor from Loyola discussed. In closing, we support passage of H.R. 4 with the goal of improving language access services to language minority voters by supporting coverage under Section 203 and Section 4E of the Voting Rights Act. Thank you very much.
And thank you very much for your testimony. We'll proceed now under the infamous 5-minute rule for questions that each of our members will have. I'm picking up a drift that most of the members of this panel are skeptics of the Supreme Court's decision in Shelby County versus Holder, and I think it was abominable myself. However, is there anybody who thinks that the Supreme Court, the current Supreme Court, is in any mood to reverse itself and to get rid of the Shelby County holding? It doesn't look like it. Okay, so we have to work then within the structure created by the court in Shelby County. There's something of a straitjacket that was imposed upon us, although one of the multiple flaws of the decision is that it was rather vague and inarticulate about what exactly the standard was for defining the legitimacy of congressional action under the 14th and 15th Amendments here. Let me pose this question. Does everybody agree that City of Bernie versus Flores is the controlling regulatory standard that we need to meet this congruence and proportionality test? I see, Mr. Adegbile, you're shaking your head.
No, so as I read Shelby County, the court spent a lot of time analyzing Katzenbach and the rationality standard, and the standard it articulated is much more consistent with Katzenbach than it is with Bernie. There was not an extended discussion of Bernie and its progeny. In fact, I know because I submitted the briefs that in the underlying briefs, both in Northwest Austin and in Shelby County, there were extensive discussions of the standard. But the court in both Northwest Austin and in Shelby County did not take up and frame the standard in those terms.
All right, so you don't think that the majority on the court today would bring a congruence and proportionality prism to interpreting the constitutionality of whatever we enact in Congress?
As the chairman knows, predicting exactly what a new Supreme Court will do, it has different personnel now than it did at the time, is a very difficult exercise. However, when these issues have been put to the court in the context of the last reauthorization, the court did not expressly adopt the Bernie standard, and it had many opportunities to do so.
All right, but we want something that's going to hold up. I mean, is it better for us to err on the side of caution in terms of thinking about this, Professor Levitt?
So I just want to, yes is the short answer, but I think H.R. 4 amply does that. I'll also say there's some sense to the
Could you
distinction.
just take us quickly through H.R. 4 through a congruence proportionality analysis?
Sure, and in this area, they're related. What the court is concerned with is that Congress is trying to redefine. The court doesn't want to let Congress redefine the substantive violations of a constitutional amendment. But I don't think that H.R. 4 comes anywhere near doing that. It takes steps that are tailored to current conditions in a way that is designed to either remedy the present effects of past intentional discrimination or to prevent and deter, in the present tense, intentional discrimination immediately on the horizon. And I think each of the provisions of H.R. 4, the coverage provision for preclearance, notice requirements, the requirement to adjust equitable relief standards, each of those are tailored, in fact, even though I agree with Mr. Degley, I don't think they have to be under Bernie. I think each of those are actually tailored to Congress's enforcement authority, not just under the 15th Amendment, but under the 14th Amendment, and as my colleague has said, under the Elections Clause.
Okay, the opponents of the Voting Rights Act say that Section 2 lacks constitutional authority under the 14th Amendment because the amendment requires a showing of purpose, but Section 2 applies to both deliberate and effective discrimination. And so, in turn, they say that a new preclearance formula cannot be based on the existence of Section 2 violations. Justice Thomas seems to believe that the Voting Rights Act does not protect against discriminatory vote dilution based on race or ethnicity, and he said as much in Cooper versus Harris. Professor Tolson, let me come to you. Is there any reading of Shelby County that casts doubt on the constitutionality of Section 2? And what's your response to the issue of whether Section 2 violations should form the basis for activating the Section 5 coverage formula?
I don't think Shelby County stands for the proposition that Congress doesn't have the authority to legislate based on discriminatory effects. I think that the court is looking for a legislative record that's a mix of both. One thing I want to point out that I think is quite pertinent here is the fact that we're focusing a lot on the 15th Amendment, right, this focus on race. There's also a branch of equal protection jurisprudence that deals with the right to vote as a fundamental right that does not focus on or require a showing of intentional racial discrimination. So if there's evidence that states are abridging or denying the right to vote and the legislative record reflects that, Congress can legislate based on that authority.
Okay, finally, and let me close on this question to you, which is, do you think we have reason to worry that we'll jump through all of these hoops to create a better coverage formula, and then the next sweeping attack on the Voting Rights Act will be to dismantle Section 5, saying the preclearance requirement itself is unconstitutional?
All you can do is your job.
Yeah, but is there a way that we can prepare for that?
I think that H.R. 4, as it stands, is consistent with current understandings of the Constitution. We can't predict what a Justice Kavanaugh or Justice Gorsuch might do, and I don't think that
But we
Congress
need to
should try
thicken up the legislative record about Section 5 to say that it is still needed.
Right, and I also think that Congress needs to be clear about the sources of authority pursuant to which it is acting. Force the court to articulate if it's exceeding the scope of congressional authority under the Elections Clause, under the 14th and 15th Amendments, not just race, though, right? It's also about voting.
Thank you very much. Over my time, and I am happy to recognize the ranking member for his questioning.
Thank you. And Professor Tolman, I tell him to do his job all the time, okay? I got a few questions for Professor Morley. What are some of the features about a federal law that makes the Supreme Court more likely to strike it down as exceeding the scope of Congress's power under Section 5 of the 14th Amendment?
If you look at the Supreme Court's precedents after City of Bernie v. Flores, in which it considered some very well-known laws as they apply to state governments, laws such as the Age Discrimination in Employment Act, laws such as the Americans with Disability Act, Family and Medical Leave Act, the types of features that the court took into account in determining congruence and proportionality included comparing the scope of the law, how much state action, how many state laws, how many state acts the federal law prohibited, comparing that to the subset of actually unconstitutional state action. So basically, the broader the law went, the more, the broader the range of its prophylactic protection, the more state action that wasn't actually unconstitutional the federal law covered, that weighed more heavily against it, and that required a proportionally greater showing by Congress that such sweeping prophylactic relief is necessary. And if you look at some of the reasons why those other laws were deemed to be overbroad under the congruence and proportionality standard, it was because, in part, they applied to all state conduct, not only intentionally discriminatory conduct, but state actions that had a disparate impact against members of certain groups. It applied to all state actions, not just intentional discrimination or not just intentional violations of constitutional rights, but also negligent or inadvertent state actions. And the court also looked to the applicability of the law, that if the law was made nationally applicable, if there wasn't an attempt to try to cabin it to places where there actually was evidence of constitutional violations, that also tended to weigh against the validity of the law under Section 5.
Specifically, are there any constitutional concerns with the Voting Rights Advancement Act's proposed definition of voting rights violation? And what are the consequences of designating something a voting rights violation under the Act?
So if political subdivisions of a state or the state itself engages in voting rights violations, enough of those over specified periods of time, and the statute has different criteria depending on whether the bill has different criteria depending on whether the state itself was involved in a violation. But basically, enough voting rights violations and the state or a political subdivision will be subject to preclearance requirements under the bill. And so the definition of voting rights violations under the bill includes violations of Section 2 of the Voting Rights Act, including violations that arise under a disparate impact theory of liability. So Section 2 of the VRA, insofar as it applies to disparate impact, is already a prophylactic protection. Preclearance is another prophylactic protection, and so imposing preclearance requirements based on disparate impact violations of Section 2 of the VRA is stacking prophylaxis upon prophylaxis. That was one of the main reasons in Coleman versus the Maryland Court of Appeals, the Supreme Court held Congress had exceeded its Section 5 powers, and it was in fact drawing from campaign finance law, that concept of prophylaxis upon prophylaxis led the Supreme Court to strike down aggregate contribution limits. So the more prophylactic protections you're stacking on top of each other, the further you are away from that core of an actual constitutional violation. Another main concern about the definition of voting rights violations is the fact that it's triggered by a consent decree or a settlement or an agreement in any case where the plaintiffs alleged in the complaint that the jurisdiction had violated the Constitution or had violated the VRA. So even if the parties settle without an admission of liability, even if a court never finds that the Constitution was violated, simply by entering into a settlement agreement, that counts as a Voting Rights Act violation, as a voting rights violation. So from a policy matter, you're going to be incentivizing jurisdictions to continue fighting cases they would otherwise be willing to settle. You're incentivizing potentially frivolous litigation simply because even a settlement would be enough to count as a strike against the state, and particularly because states and political subdivisions are often litigating under the threat of being hit with attorney's fees. They'll often be willing to settle even if they believe that what they did wasn't actually unconstitutional or didn't actually violate the VRA.
And I'm out of time, unfortunately. Thank you. I'll yield back.
Very good. The gentlelady from Texas, Representative Sheila Jackson-Lee, is recognized for her 5 minutes.
Mr. Chairman, thank you, and thank you to all of the witnesses who are here before us today. Let me ask, Debo, your response to Professor Morley. And here's my question. Is it layered upon layer? Do you feel states would be so generous that if you just gave them less of a layering, they would respond generously, as been noted? And then let me ask the question, as we know, Section 2 is the hit and run. You've already been hit, the car has already escaped, and you're laying on that side of the highway, bleeding, and maybe an ambulance will come and rescue you. How do you perceive this analysis as it relates to where we are today?
Thank you for the question. I would say in the first instance that the bill contemplates a range of conduct, all of which can lead to a finding that a jurisdiction needs oversight. Much of the conduct could be intentional. There are voting rights violations that can be determined through the use of an effects standard under Section 2. But when you look at what you need to do to prevail in a Section 2 case, the indicia and the proof in the underlying statute is essentially like intent light in some ways. There are many specific things that are indicative of intentional conduct or conduct certainly that has impact that is framed in the context of specific behavior.
You're already harmed.
And of
You're
course,
already harmed.
there is an impact and a minority voting harm. So this is not a statute that leans entirely on one side or the other. As we said earlier, the prophylactic power of Congress to enforce the underlying right is very substantial. And in the Bernie cases that my colleague cites repeatedly, all of those cases pointed to Section 5 of the VRA as being the iconic statute, the statute that was the standard, right? So to take the idea that the Bernie cases somehow disable a statute designed to protect voters against discrimination in a preclearance way is inconsistent with the jurisprudence, no matter how you slice it. As to your point about Section 2, Section 2 is very important, but it's a post-implementation remedy. And both Professor Levitt and I spoke about the difficulty of that timing difference. When you have a Section 2 case, they're very expensive, they take a long time. Very often the benefits of incumbency have vested, and you can't unring the bell. That is what has been lost with the preclearance protection. In jurisdictions that have patterns over time of discriminatory voting conduct, you need a different measure. And in fact, the history has been that those two measures work together.
That's the point I was making when I said the hit and run and you're waiting for an ambulance, which is you've already been harmed under Section 2. So you bifurcated the answer and then responded to my Section 2 question. And I appreciate your response. Professor Tolson, I'm impressed with your work suggesting our broad authority in the 14th and 15th Amendment and our ability to regulate elections. Do you think that we could have had a different decision if the court had included your analysis as part of their assessment on the Shelby case?
Yes, ma'am. I do think that I did file a brief with a group of law professors arguing that the Elections Clause provided additional authority for the predecessor to H.R. 4, but the court didn't discuss the Elections Clause, and I just think the court was kind of committed to striking down the preclearance regime. So, yeah, I do think that we could have had a different outcome. Can I make one other point, ma'am, with respect to your other question? I just want to point out that a lot of courts don't find intent because they don't have to, but that doesn't necessarily mean that intent is not present. So if you look at the Texas voter ID case, the lower courts found that intent was present, even though a panel of the Fifth Circuit later just relied on the Section 2 analysis. And so I think that the question of relying on Section 2, whether or not it's constitutional, is actually quite complex because a lot of courts, because Section 2 does not require it, they do not use an intent analysis. And so I think that the current bill takes that into consideration.
Mr. Levitt, thank you so very much. Mr. Levitt, let me pose again Mr. Morley's long discussion, the chilling effect that H.R. 4 would provide. It quashed the generosity of jurisdictions. How do you respond to that?
Well, I think it only chills discrimination, and so I'm not against the chilling effect on discrimination. The preclearance regime is designed to see whether a provision is discriminatory or not. It's a simple check before the provision has the opportunity to do damage in the real world, to execute the hit and run, as you suggest. It is the sort of grappling with federal government authority that is baked into the 14th Amendment, that's baked into the 15th Amendment, that's baked into the Elections Clause, which all give Congress the not only authority but responsibility to make sure that local jurisdictions administering elections aren't discriminating. And with respect to the prophylaxis, really all of these patterns, as Professor Tolson said, as Mr. Degblay said, are looking for patterns of discrimination, warning signs that more is on the way, that intentional discrimination is on the way. You're not looking for exact gotcha moments so much as an overall pattern that leaves deep concern. That's the reason for the deterrence, that's the reason for the prophylaxis, and I think it's amply within congressional power, as Mr. Degblay pointed out.
Thank you, Mr. Chairman. I yield back.
Thank you very much. Let's see, we are recognizing now, is it Mr. Klein?
Thank Mr. Klein for yielding. I'm going back to Professor Morley again. You gave such great answers earlier. We'll keep going. Why would you say this whole argument is framed about Congress's power under Section 5 of the 14th Amendment being the main issue here? And I'm wondering why Congress can't simply enact the Voting Rights Advancement Act under its other constitutional powers, like the Elections Clause or Section 2 of the 15th Amendment.
Court has never revisited. I believe the court is likely to construe Section 2 of the 15th Amendment the same way as it interpreted Section 5 of the 14th Amendment in Birney for a few reasons. The two provisions, Section 5 of the 14th Amendment and Section 2 of the 15th Amendment, they have materially the same language. They're structured the same way. They were adopted roughly contemporaneously with each other as part of the Reconstruction amendments. The purposes, the original intent underlying these amendments about empowering Congress to enforce the guarantees provided by the substantive constitutional amendments themselves were the same. Historically, the Section 5 and Section 2 were read in pari materia with each other. So during the first round of cases in which the court upheld the Voting Rights Act, the court analogized both Section 5 and Section 2 to the Necessary and Proper Clause, right? Let the ends be legitimate. It construed both of those provisions as giving Congress virtually plenary authority over the area. And so particularly given their virtually identical language, structure, history, as well as history of interpretation, I think it's overwhelmingly likely the court would apply that Birney analysis to Section 2 of the 15th Amendment. With regard to the Elections Clause, yes, Congress has far greater power over federal elections than it has over state and local elections. The congruence and proportionality analysis of Birney is relevant insofar as Congress is trying to target state and local elections rather than just federal elections. So certainly were Congress only regulating federal elections, as it has under many other laws like the National Voter Registration Act, it would have much greater flexibility. And I'll also note that historically states have generally chosen to apply federal laws that regulate just federal elections to state and local elections as well, even though they weren't required to, simply because they don't want to run two separate sets of election systems parallel to each other.
So if Congress doesn't adopt a new statutory formula for preclearance, what other mechanisms exist to ensure that states and localities don't violate voting rights?
So one option, which several other witnesses mentioned, is the notion of ex post facto litigation, where a locality enacts a statute and then either affected voters, civil rights groups, other plaintiffs go to court and obtain a restraining order, obtain a preliminary injunction. Obviously, the Department of Justice is also in a position to do that. The other main option, though, and one which has been very heavily underutilized, is under current law. Section 3 of the Voting Rights Act allows for bail-in, and this is an option that some courts have been reluctant to utilize. This is an option where if a court finds that a jurisdiction has engaged in intentional discrimination, it can bail in that jurisdiction to preclearance, and so you have an actual constitutional violation, and you would be then subjecting that offender, that jurisdiction, to preclearance. As I mentioned, courts have been reluctant to do this. This committee could consider the option of strengthening Section 3 of the VRA to either a presumption of bail-in or even mandatory bail-in if a court finds intentional discrimination.
And that the amendment to that language would be a pretty simple statute, wouldn't it? Just be a couple of lines, right?
Yeah, yes,
You're just changing a couple of terms.
yes.
I'll yield back, Mr. Chairman.
Thank you very much. Ms. Escobar, you are recognized for 5 minutes.
Thank you, Mr. Chairman, and thanks so much to all of our panelists. Mr. Adegbile, since you argued the Shelby County case for the respondents, for the average American, can you please describe in layman's terms what the Supreme Court held?
In layperson's terms, the Supreme Court did not like the standard that Congress had adopted and reauthorized to subject certain places in the country to pre-implementation review of their voting changes. That is to say, states and localities everywhere pass voting laws and change voting practices somewhat regularly. Some places in the country have histories of lots of discrimination in voting. And so the Section 5 preclearance system was designed to focus on those places because filing individual cases was not enough. Why? Because after people won those cases, the jurisdiction would find another way to discriminate against the targeted population. And so Section 5 changed the game because it said rather than presume that you get to implement these things, we're going to look at them first. We're going to kick the tires to make sure that you're not visiting discrimination on the communities that have long suffered under this system. And we're going to make you come forward and show that you don't discriminate intentionally or it doesn't have a discriminatory effect. The Supreme Court didn't like the way that Congress identified those places that would be subjected to this system, and that's why today we're talking about the new way in which Congress is intending to have a more current system of identifying the places that could be subjected to this. And frankly, this bill makes everybody eligible to be under the preclearance regime, but also has a clear path to get out, and it's sort of dynamic and renewing.
Excellent, thank you so much. And Ms. Romero-Kraft, I hail from the great state of Texas, where we have legislators and we have leadership that has chosen to make voting much more difficult for minority communities and minority groups. And I was really taken by your description of what you witnessed in Florida and the impact that this has had on voters, specifically voters who are recent immigrants and whose rights really have been violated. And so I'd like to give you the remainder of this time. I think it's so important through these hearings for the American public to understand the impact, the human impact of changes in law or changes in policy. So can you describe for the American public more of what you've seen in Florida as a result of what the Supreme Court upheld?
Sure. Thank you, and thank you for the time. So we are actually out in the field a lot. Thanks to the coalition members, we are able to run election protection activities to the extent our resources allow. But what we find is the current climate, is specifically for the Latino community, there is a lot of fear about exercising rights, even for folks that are citizens. Take, for example, Puerto Rican citizens. It's not just relegated to Florida. We travel to other southern states. And so what we find is that folks are hesitant to ask for assistance, even if they raise an issue that could be, and that in some cases is specifically a violation of voting rights law, they are hesitant to bring anything forward. So all of this has a chilling effect, and if individuals think that they're not going to be protected or heard, we've had folks even at the registration phase where they're trying to register to vote, where they're met with folks that are unable or unwilling to provide them the language assistance that they require and is mandated under law, they won't register to vote. So all of this is to say that it's very difficult even to create this relationship when you're looking for folks that have issues, so that they trust you and that they trust that you're doing the best under what the law provides, and that the folks that are elected officials also should be mandated to do their work. It's a very difficult position to find yourself in a room full of elected officials who are resisting to make changes that is required under the law. And something I think that folks should understand as well is that, you know, Section 4E applies throughout the country. So any voter who is educated in Puerto Rico in Spanish has the right to ask for language assistance to all of the materials related to the election in Spanish. So I think that's very important to know. And as well as the Section 203 covered jurisdictions, we still see violations, even though a lot of those jurisdictions are constantly reminded of their continuing obligation to language minority voters.
Thank you so much. My time has expired. I yield back.
Gentlemen, ladies, time has expired. Thank you very much. And I now recognize Mr. Armstrong from North Dakota.
Thank you, Mr. Chairman. First of all, Professor Tollefson, I'm stealing all you can do as your job. I think I would have liked taking your class in law school. I'm a big fan of Teddy Roosevelt in the arena, but it's a little verbose, and that is fantastic. And along those lines, when we're talking about current makeup of the court, I'm reminded of what an old trial lawyer told me when I started, and that was win the jury trial, and then you don't have to worry about the appeal. Unfortunately, in these cases, we don't have it. But I want to go back to something Mr. Morley said, in that we always think of these cases in wins and losses, and we don't always account for settlements. And so when we're talking about like the definitions in 3A1, I come from the only state without voter registration. We have complete vote by mail counties in some areas. I always use the line, there's no such thing as a federal election, there's just local elections that elect federal officers. But when you're talking about the DOJ and, I mean, the opportunity for mischief, and I'm going to bring in the private right of action because you actually write in your testimony to strengthen that. But my concern is I mean, just on a resource, discovery and paper, all of those types of issues, primarily when you take a state as big as North Dakota and deal with one issue, I mean, you could very easily see a small rural county settling the case immediately just because they simply do not have the resources to deal with the issue. And so that one county in north central North Dakota could essentially trigger an opt-in for the whole state. Is that how am I reading this right?
That would apply not just to that.
And the settlement, I mean, you don't I mean, settlement would be a part of that conversation, right? This isn't all just wins and losses in those areas.
Right. Under the proposed language in H.R. 4, if a jurisdiction enters into a consent decree, a settlement, or any other agreement, even if there's no admission of liability, as long as that initial complaint had an allegation that there was a constitutional violation or a Voting Rights Act violation, that settlement would count as a strike. It would count as a voting rights violation.
So then would even a decision to amend a voting practice, that could do it as well, right?
If that were part of the settlement agreement or part of the consent decree, absolutely.
Okay, and now just how does the private right of action work? Or how do you envision it working? Because that's, I mean, far be it from me, but I mean, having one, because you strengthen it in your testimony. I mean, you give some very things. I'm not worried about when it works well. I'm worried about when potentially people are interested in creating mischief.
So one of the provisions of H.R. 4 allows current provisions of certain federal voting rights laws that currently are only enforceable by the Attorney General to be enforced by private litigants as well. And the way H.R. 4 is currently drafted, only voting rights laws that are aimed at preventing discrimination on the basis of race or color would be subject to private enforcement. My suggestion for the committee to consider is, in allowing private enforcement of voting rights laws, essentially extend this private right of action not just to voting rights laws aimed at racial discrimination, but at all voting rights laws, precisely because on the one hand, you would still have Article 3 standing limitations on who is allowed to sue, so you couldn't have a random person just walk in off the street and start suing jurisdictions. It would have to be someone who suffered an injury in fact, so an adversely affected candidate, an adversely affected voter, potentially a political party. And by allowing private enforcement of voting rights laws, you ensure that the rules of the road, the fundamental rules governing the election, will be enforced, and that enforcement isn't hung up and cases aren't thrown out of court on technical, non-merits related grounds, such as what happened in 2008 in a case brought about a maintenance of Ohio's voter registration lists, Ohio Republican Party versus Bruner, where the court says there's no cause of action, so we're not even going to bother looking at whether election officials are violating federal law or not.
But I'm assuming that a private course of action, same thing, right? There's not just wins and losses, there can be settlements, and they would qualify in the same way as if it's brought by in any other way, correct?
Absolutely. Under HR 4, if there's a settlement and if one of the allegations in the original cause of action involved racial discrimination and violation of the Constitution or in violation of federal voting rights laws, then any attempt to settle that case or a successful settlement, I should say, would count as a strike, would count as a voting rights violation.
Thank you. And then I'm going to just ask Mr. Rich to comment on that, just about how can we assure this is narrowly tailored enough that it does what we want it to do without having this area where, I can't have rural districts settling just because they have to settle type of thing. I don't even sure I disagree with the private action. I just want to make sure that we are thinking about not only the ways in which it's used properly, but the ways in which it's used improperly. You've done this for decades.
I'm of the opinion that there's a private right of action to enforce most of the Voting Rights Act. And it's worked over the years. There's all sorts of protections in the courts for private rights of actions brought against jurisdictions. Indeed, I think the jurisdictions have more resources usually than the private plaintiff does. So I don't see that as a major problem.
And thank you, my time's up. Agree. And I agree with that in most jurisdictions, just probably not most jurisdictions in my district.
Let me, Mr. Rich, before we conclude and before I express appreciation for all the witnesses that are here and thank the ranking member for his presence and his thoughtful questions, let me editorialize and say that I think the Shelby case is one of the most significant moment in history that really brings lifeless or makes lifeless some of the promises of the Constitution, and particularly some of the amendments in the Bill of Rights. So I think it is important for this Congress, in a nonpartisan and bipartisan manner, be able to give the tools back to not only individual voters, but to governmental entities. One of those points was a comment that Attorney General Lynch made regarding the DOJ's ability to send observers. And let me be very clear. I am in a voting rights district. I have never had a district that has been drawn without either court approval or instruction. And that means every election I am asking for observers because my constituents are calling ahead of time about the fear of being suppressed. So her point was that federal observers have been severely curtailed as a result of the Shelby decision impacting elections from November 2016 onward. What has been the role and importance of federal observers in protecting minority voting rights? And how has the loss of most of the federal observers impacted elections on the ground in states like Florida and Texas? And might I say, they give you an 800 number or I'm calling ahead of time, and I truly feel the impact in the smaller number of observers who are able to be out in the field. Mr. Rich?
There's no question that the federal observer provision is one of the important parts of the Voting Rights Act. Go back to when the Voting Rights Act was passed. The importance of having federal observers at those elections was crucial. And you're still seeing it in your district. You need them because there's racial tensions at these elections. The Shelby County reduced the number of observers that could be certified by the Attorney General considerably. The only way you can get federal observers now is if there is a court order authorizing the Attorney General to certify them, because under the interpretation that the Department of Justice has given to the observer provision in the 65 Act is because there's no longer any Section 5 jurisdictions, which were always the jurisdictions that could be certified for federal observers. That's gone, and therefore there's no way to certify federal observers for formerly Section 5 jurisdictions. I just think losing that is not as important as preclearance in my judgment, but pretty close. And over the history of the voting rights enforcement by the federal government, the Federal Observer Program has been one of the most important that we have, and the procedures and efforts that have gone into it have been considerable. OPM trains observers to be neutral. They're able to be in voting places and in where votes are counted to be sure there is no fraud or discrimination. And so I fully agree with what former Attorney General Lynch said, that losing this has been a real step backward.
Well, let me thank each and every witness. Thank you, Mr. Rich, for your answer. I think the other telling point is that in 2020, without Section 5 districts, we'll be going into redistricting without that protection. Let's hope we'll have some protection before then. Again, let me thank each and every one of the witnesses for what I think has been an insightful and not inciting, but insightful contribution to the task that Congress has, which is to set the record. Before I close, Mr. Ranking Member, I want to, without objection, the opening statement of the Chairman of the full committee will be entered into the record, Mr. Jerry Nadler. Without objection? This concludes today's hearing. I want to thank all of our witnesses for appearing today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. With great thanks, this hearing is adjourned. A lot of chords.
Oh, yeah.
See you later.
I'm like, man, I should just grab a packet so it doesn't have all those holes in it.